All right, guys. Y'all, listen, y'all. I was just on my other live, and then I start seeing stuff dropping. I'm like, Lord have mercy. I haven't even done my hair. Oh, I look. Cheers. Where's Hippie? Hippie, where are you at? Where's Hippie? Where's two two mics and a two mouths and a mic? Where's everybody at? Where hipster? Where's she? Guys, we got four responses that we're about to get into. Four responses from the state. Four responses we got. Hold on a second, y'all gotta get these things out. It's about getting this work on, y'all. Okay, we got all four responses. Yeah, I had a class to attend, but I guess I can't attend my class. I had a class to attend, but I'm working right now. All right. Then I have something else I want to bring to you guys in regarding to a case that was just recently overturned. That can help YSL. Just right here in the Superior Court of Fulton County, something just happened, and I was going to bring that to you guys' attention. But while we're doing these motions and hold on a second, because I just sent. Okay, let me okay, sorry, I forgot to put the link in there for the chat. Hold on a second. Hold on a second. Okay. All right, here we go. Good morning, everybody that's just coming in. Good morning. We got a whole bunch of, y'all, my head is jacked up, but I don't care. I'm here to do work for y'all. If I really care, I wouldn't have my thing on if I did. All right, here we go. Here's two minds and a mic. She is here to read for us. Let me go ahead and put her on. And then I am going to share the screen for the first response. All right, are you ready?
Getting it pulled up now. I do have 4 of them. Which one do you want to go first with?
The first one, the one that says state responds assuming facts not in evidence. That one.
Okay, got it. One moment.
I gotta close all my other thing here. I gotta close some of this stuff here. I got so many things open, y'all. So many things open. I gotta close some stuff out. Okay, hold on a second. Okay, I gotta go in here. Just bear with us a second, guys. I'm sorry I'm not prepared. That's because everything started coming down so quickly. I just gotta close stuff up. I had all Bootsy stuff up from yesterday. Okay, we gotta close that one out. Okay. All right, you ready?
One moment. I'm closing everything out.
Your mic is loud again.
1 second.
Hey, everybody that's coming in. Hello, 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 hello. You said I always do the most. You said I always do the most. Should I take it negatively or should I take it positively when you said because you always do the most? I'm trying to think positive now, y'all. I'm trying to think positive. I just want to make sure it's a clarification of what you're saying about I always do the most. Hey, Jeremy. Not Jeremy didn't say that. Somebody else said that. I just want to get some clarification. Cavell said ignore. Hey, it's called trying to be prepared for you guys, and I'm not prepared because I didn't think it was going to come in.
Is the mic a little better?
No, well, it's not good, but we'll deal with it.
Hold on, I'm gonna just change it.
It's just so loud.
I'm gonna change it.
Good morning, everybody that's coming in. Good morning. Good morning, everybody. There's going to be a whole bunch of motions coming down, well, response to motions. So just bear with us a second. I was busy doing something else and it started dropping. That's why unpreparedness is always me.
Is that better?
Not really, but go ahead.
Okay, well, I'm turned down on all of them. I'm at the lowest settings, so. All right. State of Georgia versus Jeffrey Williams. State's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. Introduction on June 10, 2024, Defendant Williams moved this court to vacate proper rulings on state objections precluding cross-examination questions, which assume facts not in evidence. Defendant Williams does not include a request for specific relief or provide authority to substantiate his request. Instead, Williams cryptically asserts that somehow his right to effective cross-examination has been curtailed. Trial court correctly sustained state objection to questions, assuming facts not in evidence. Williams' motion should be denied. Oh, that was in caps. Argument in citation of authority. At the outset, Williams never provides authority that inquiring into unproven and irrelevant areas, to wit, facts not in evidence, classifies as a specific mode of cross-examination imparted by constitutional requirement. See generally Johnson versus State. Unlike many other modes of impeachment, attacks on witness bias are constitutionally guaranteed. Even grounds that are constitutionally protected, however, may be subject to judicial controls. Lucas versus State. Footnote 1, on July 10, 2024, Defendant Williams filed an amended motion. Defendant Williams' motion addresses multiple separate evidentiary rulings. This motion addresses paragraphs 10 regarding state objections to assuming facts not in evidence. And then it says Lucas versus State, the right to inquire into partiality and bias, however, is not without limits. The Fifth Circuit has made it clear that questions which assume facts not in evidence are not constitutionally protected and subject to exclusion by trial courts pursuant to the rules of evidence. Federal Rules of Evidence 611 provides the court shall exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1, make those procedures effective for determining the truth, 2, avoid wasting time, and 3, protect witnesses from harassment or undue embarrassment. Federal R Evidence 611, the rules permits courts to preclude questions and obscure truth because they are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. United States v. Fields, emphasis added. Williams' motion attempts to constitutionalize areas of cross-examination that is not so protected, even assuming arguendo that questions assuming facts not in evidence were of the same stripe as an area like bias. Rules 401, 403, and 611 would preclude Williams' proposed inquiries. A. Williams' Sixth Amendment right to effective cross-examination was not infringed by disallowing questions seeking to elicit facts not in evidence. Pursuant to both OCGA 24.1.103C and 24.6.611, the trial court has correctly prohibited Defendant Williams from posing questions that assume facts not in evidence. OCGA 24.1.103C holds that jury proceedings shall be conducted to the extent practical so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury, emphasis added. Footnote 2, see Carlson and Carlson on evidence, comparing Georgia and federal rules, 24.6.608, 24.6.622, 9th edition, they're just citing, and Georgia advocates. Courts are mandated per OCGA 24.6.611 to exercise reasonable control over the mode and order of interrogating witnesses and presenting of evidence. In order to make the interrogation and presentation effective for the ascertainment of the truth, reading these statutes in conjunction with another court, courts are authorized to prevent counsel from asking questions in the hearing of the jury that are, hold on one second. Asking questions in the hearing of the jury that are premised of inadmissible evidence to facilitate ascertainment of the truth. Defendant Williams asserts that the court's substantiate of objections for questions that assume facts not in evidence curtails his Sixth Amendment constitutional right, but cites no legal authority for that proposition. Case law explains that the Sixth Amendment provides two types of protections for a criminal defendant: the right physically to face those who testify against him, and the right to conduct cross-examination. State v. Burns. 306 Georgia 117-121, 2019, citations and quotations omitted. However, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way, and to whatever extent the defense might wish. Emphasis in original, citation omitted. Furthermore, trial judges retain wide latitude to impose reasonable limits on cross-examination based on concerns about, among other things, confusion of the issue or interrogation that is repetitive or only marginally relevant. All defendants have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses the state calls in this trial. The state will not object to cross-examinations that is legally sanctioned. Williams' right to cross-examination is not abridged where the examination is limited by the trial court to relevant matters by proper questioning. Section B, objections to assuming facts not in evidence are proper. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they are considering information that is never properly admitted as evidence in trial. In United States versus Almazar, the court overturned a trial judge's decision to set aside a jury verdict based on insufficiency of the evidence because of the district court assumed facts not in evidence and made unsupported assumptions. Defendant William improper questions which assume facts and evidence could confuse the jury during deliberations, similar to the trial judge in Almazar in Satterfield versus State. Appellant enumerated as error at trial counsel's failure to object to the prosecutor's questions of a witness which improperly assumed that these defendants had created the mess, a fact that the witness did not know and which was not directly in evidence. Ultimately, the court held the trial counsel's failure to object to these improper questions could be qualified as a reasonable strategic decision and did not find prejudicial error. See ID at 848. Nonetheless, the fact that the Supreme Court diligently undertook analyzing appellant's objection to improper questions that assume facts not in evidence underscores the validity of such an objection. Defendant Williams classifies such objections as specious, but the Supreme Court of Georgia and federal courts view them as unequivocally valid. Moreover, Williams seek to ask questions that imply matters that at best Williams cannot substantiate. For example, Defendant Williams asked Detective, I believe, Belknap, do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? To begin with, the question is predictated on a falsehood, as this court's detailed order on the introduction of gang lyrics proves this is not a true threat case, and not one defendant is being prosecuted for expressive activity of any kind, Exhibit A. Plus, this line of questioning is unsourced and in conflict with known proof. No evidence had been introduced regarding national prosecution statistics on defendants, lyrics in criminal trials. This question also assumes that only rap lyrics have been prosecuted and thus is premised on evidence never admitted at trial, a point that was refuted in the state's briefing and hearing on the admissibility of gang lyrics evidence. Similarly, Defendant Williams' counsel asked Special Agent Racy if he knew that Dolly, Defendant Williams' sister, was in a relationship with Jimmy Renfrey in 2015. State objected because there had been no evidence that the two of them were in a relationship in 2015. Williams does not have a right to float unsupported and unsupportable distractions using sworn witness as the vehicle. Therefore, Williams requests to prohibit this court from sustaining any further objections to questions that assume facts not in evidence should be rejected. Conclusion. Williams' assertion that his Sixth Amendment rights have been curtailed by the court's sustainment of the state objections to questions that assume facts not in evidence is invalid and unsustainable. There is no constitutional or statutory right to ask irrelevant and unsupported questions during cross-examination. The prior evidentiary rulings on this matter have been in accord with the Georgia and federal Constitution and rule of evidence. Williams' motion there should therefore be denied. Respectfully submitted this 26th day of July, Adrian Love.
Okay, can you do me a favor? Go back up here to the footnote number 11 and 12. Read those, 13, 14.
On page 4?
5, page 5.
Okay. So they cited Watch Live, day 30 of YouTube. That's footnote 11, 6/12/04 to 6/12/15. Footnote 12, Chief Judge Glanville ordering granted admission of evidence of lyrics at trial, November 27, 2023, at page 5. Court found no defendant in the in-state case is being prosecuted for a charge involving a true threat or any exercise of any right protected by the First Amendment. Furthermore, this court finds that in neither briefing nor argument did any defendant demonstrate to the contrary. Emphasis added. It should be noted that no defendant or group on their behalf filed any motions challenging the legal analysis in this court order on the admissibility of gang lyric evidence, much less sought a certificate of immediate review related to same. 13, in fact, as the state's written brief on the admission of gang lyrics demonstrates, those statistics show low numbers of introduction of lyric evidence in gang prosecutions when arrayed against the size, scope, and volume of gang crime. State's second supplemental motion in limine to admit evidence of lyrics at trial, November 3rd, 2023, at page 16. Footnote 14, State supplemental motion in limine to admit evidence of lyrics at trial, December 14th, page 3, footnote 3 and 4. Watch live, Young Thug, YSL Rico trial, Georgia versus Jeffrey Williams, lyric motion hearing, YouTube. And they also cited another YouTube at 2 minutes to 10 seconds all the way through 24.
Thank you. All right. So, guys, that is the first motion. Oh, we got 16, 17. Forgot about those two.
Well, I thought I thought it was funny that it says that they did not seek that they did not, what is it at? Oh, they did not seek a certificate of immediate review. Those were denied every single time.
They sure did. They got denied.
They've been denied on face value every time.
Okay. Thank you. Thanks so much. And we got a lot going because we just got another one just came in from the defense side against the state. So we got 3 more of the state, 1 of the defendant. So it's going to be a whole bunch of responses today, guys. So just stay with me. We're going to bring it all to you. All right.
Do you want to discuss that one and then go into the second one?
No, we're just reading right now. We're just
read.
Because we got a lot to read. I don't want to get stuck doing 10-hour live and we just, you know.
Okay, I have the state's response in opposition to defendant's motion for correct ruling on adoptive admissions.
I need number 2. It says number 2.
Yep, that's number 2.
Okay, ready? Let's go.
All right, State of Georgia versus Jeffrey Williams, state's response in opposition to defendant's motion for correct ruling on adoptive admissions. Introduction. Despite binding Georgia in persuasive federal precedent authorizing their admission on July 10, 2024, defendant Williams moved this court to vacate, correct prior rulings on the introduction of adopted admissions under OCGA 24.8.801-2B, Rule 801D-2B. Defendant Williams does not request specific relief on this matter, nor does Williams delineate which this court should eschew binding and persuasive statutory and case law. Nonetheless, the trial court has correctly ruled on adoptive admissions in this trial in accord with the Georgia federal rules of evidence. Williams' motion should be denied. Argument and citation of authority. Sending Georgia's former ban on their introduction to oblivion, the Supreme Court of Georgia, in accord with federal precedent, approved that the introduction of an adoptive admission in criminal cases, State versus Orr, In the state's briefing argument and the court's order on the introduction of gang lyric evidence, the concept and application of adopted admissions were to delineated in considerable detail. The state incorporates the material by reference and provides the following in summary and supplemental response. Rule 801 D2B authorizes the previous court's rulings on the introduction of adoptive admission and governs a trial court's consideration of the same. Rule 801 D2B states A, admission shall not be excluded by the hearsay rule. An admission is a statement offered against a party which is a statement of which the party has manifested an adoption or belief in its truth. Emphasis added. Defendant Williams is partially correct in asserting that mere silence by a party opponent in the presence of another statement standing alone does not automatically equate to an adoptive admission. However, a defendant's silence may, in certain circumstances, communicate that he has adopted another person's statement as true, make that statement admissible under Rule 801. In evaluating whether evidence qualifies a defendant's adoptive admission under Rule 801-82B, the trial court must find that two criteria are met. One, the statement was such that under the circumstances, an innocent defendant would normally be inducted to response. And two, there are sufficient foundational facts from which the jury could infer and the defendant heard, understood, and acquaintances in the statement. After this initial determination is made by the trial court, the jury is then responsible for making the ultimate determination of whether the defendant adopted the statement as true. A clear example was found in Wilkins, where the court found it was reasonable that a statement referring to a bloody shirt in the trunk of a car that appellant drove up and was standing next to as the shirt we used to wipe blood and fingerprints off a gun is the kind of statement that would normally prompt an innocent person to clarity that there was not part in the we. The foregoing said a direct confrontation with the accusatory statement is not always coupled with lack of denial required by the application of Rule 801-82B. See, for example, the cases provided below. United States versus Hankton. Holding trial court did not abuse its discretion by admitting statements in a rap video the defendant silently appeared in as an adoptive admission. Neal versus State. Holding no abuse of discretion by a trial court in finding defendant's pre-arrest silence was an adoptive admission when defendant stood silent after being verbally accused of having sexual intercourse with a minor. United States versus Carter. Holding statements were improperly admitted as adoptive admissions when defendant remained silent in the presence of co-defendants, discussion implicating them in all illegal smuggling activity. Conclusion. The trial court's prior evidentiary rulings on adoptive admissions have been in accord with Rule 801-82B and case law of the same. Adoptive admissions should be admitted in Georgia criminal trials. Williams' motion should be denied. Respectfully submitted this 26th day of July, 2024, Adrian L. Love.
Okay, can we go back up and do these footnotes? Number one.
What was that? I'm sorry.
The footnotes. We forgot.
Oh, let me go back. Sorry. Footnote 1, Defendant Williams' motion addresses multiple separate evidentiary rulings. This motion addresses paragraphs regarding adoptive admissions under OCGA 248801-2B. Footnote 2, see Carlson and Carlson on evidence, comparing Georgia and federal rules, 248801-D2B, 9th edition, 2024. Carlson and Carlson's Guide to Evidence, author Essential Foundations for Georgia Advocates. Footnote 3, Chief Judge Glanville order granting admission of evidence of lyrics at trial, November 27, 2023, at page 27, subparagraph states second supplemental motion in limine to admit evidence of lyrics at trial, November 3rd, 2023, at page 5, paragraph 4. Footnote 4, Wilkins v. State. And that's it.
Thank you, ma'am. I appreciate you. Okay, guys, we're going on to number 3, response number 3.
Okay, State of Georgia versus Jeffrey Williams, state's response in opposition to defendant's motion for correct ruling on self-serving hearsay. Introduction. Oops, sorry guys, backed out. Introduction. Williams' request to the court to grant blanket relief going forward on self-serving statement objections despite hearsay proscriptions should be denied at this time. Moreover, Williams has made no offer of proof detailing how he can possibly satisfy any hearsay exceptions attendant to self-quotation evidence.
Hold on a second. Nick just sent super chat. Thank you, Nick. And it says Steele's motion about lyrics are months old. If the state intend to reply to all motion filed, that's Glanville denied. There must be several dozen replies to be expected today. Yes, I agree. All right, go ahead. I'm sorry.
Okay. Trying to see where I was.
I think it was almost at number 2.
Okay, argument and citation of authority. Pursuant to Legislative Act, hearsay has been redefined as a statement other than one made by the declarant, which, while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Darts v. State. A party may not introduce his or his own statement unless a hearsay exception rule applies. And then Malouf v. Marta. Accordingly, self-serving statements where parties attempt to introduce their own prior statements absent an applicable hearsay exception are routinely determined inadmissible. Swan v. United States. Footnote 1, on July 10, 2024, Defendant Williams filed an amended motion. Defendant Williams' motion addresses multiple separate evidentiary rulings. This motion addresses paragraphs 2 through 9 regarding self-serving hearsay statements. It says self-serving statements are not exempted from the hearsay rule by the Federal Rule of Evidence 801D2A or any other exemption or exemption that are thus inadmissible hearsay. In accord with OCGA 248801C and 248802, this court correctly prohibited Williams from eliciting self-serving hearsay, self-quotation evidence. Pursuant to OCGA 248801C, hearsay is a statement, other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Absent an exception, hearsay is not admissible at trial. OCGA 248802. The burden is on the moving party to establish one of the hearsay exception applies to admit the statement Taylor v. State. Williams has not made any offer of proof demonstrating that Williams can satisfy any hearsay exception applied or that Williams is introducing the evidence for a non-hearsay purpose. Therefore, defendant Williams' out-of-court statements, whether classified as self-serving or self-quotation, are inadmissible. The state under OCGA 248801 D2 can introduce Williams' statements as admission by party opponent. However, this hearsay exception does not extend to a party's attempt to introduce his or own statements through the testimony or other witnesses. United States versus Ford. Citation and quotation omitted. This court correctly sustained the state's objection to self-serving hearsay because Williams failed to address, much less overcome, his burden of proving a hearsay exception applied to his self-quoting statements. Williams asserts he primarily wants to introduce defendant Williams' lyrics. Footnote 2. See also Carlson and Carlson on evidence, utilizing the term self-quotation. Footnote 3. Should Williams believe that this is evidence that is admissible, he also failed to make an offer of proof pertaining to these matters as required by law. See OCGA 241103. See also COE 9 at 241103, 246611, Carlson and Carlson, Carlson's Guide to Evidence. Footnote 4, CCO3 at 24801A, and footnote 5, see United States versus Roberts. Holding defendant statements were not necessary to alleviate a misleading impression, but were instead self-serving hearsay, emphasis added. See also United States versus, and then that footnote cuts off, it's not finished. And social postings. Defendant Williams' self-quotation of his own lyrics and social media postings are inadmissible hearsay. Conclusion. Williams has not proffered or otherwise made an offer of proof to demonstrate that any hearsay exception applies to the self-quotation evidence Williams wishes to introduce. Absent that, Williams merely seeks to inject rank hearsay into this trial in derogation of binding Georgia and persuasive federal law. The state respectfully requests this honorable court deny Williams' motion and request for future relief because prior evidentiary rulings on this issue were in accord with the Georgia federal rules of evidence. Respectfully submitted this 26th day of July, 2024, Adrian L. Love. And then the footnote picked up at the bottom for 5, hold his own prior out-of-court statements because they are hearsay and not admissible. Quotation and citation omitted. Footnote 6, defendant Williams' motion at paragraph 7, and footnote 7, CCOE 9 at 248801A, and C in A, defendant self-serving extrajudicial declarations are inadmissible unless they fall within a hearsay exception. That is, defendant cannot get self-serving hearsay statements into evidence without first waiving the Fifth Amendment and testifying. Citation omitted.
Okay, question. Okay. Why is she putting those things denied in capital letters like that?
Yeah, that's what every single one of them have been in capital letters. There's a lot of emphasis added into a lot of parentheses as well.
This is crazy.
But one says that there was no motion, and then in the footnote, it states that the motion was in there. So I'm a little bit confused right now.
Yeah, it's weird. Okay, we're on our last one from the state, which is number 4. Oh, I'm getting tired already, y'all, with her. I'm getting tired with her motions. All right, here we go. Okay, let me see. Oh Lord, did you hear her yelling down there? Hold on, I'm on mute.
Ready?
I'm ready. I'm muted, so it's gonna take me a little minute
Okay.
to mute myself. But go ahead, because I'm trying to mute because my mother's making a lot of noise down there.
State of Georgia versus Jeffrey Williams. States respond to defendant's motion in opposition for correct ruling on vague questions. Introduction. On June 10, 2024, Williams moved this court to vacate correct proper rulings on state's objections precluding cross-examination with vague questions. Williams does not include a request-specific relief or provide authority to substantiate his request. Instead, Williams cryptically asserts that somehow his right to effective cross-examination has been curtailed. The trial court correctly sustained state objection to Williams' vague questions and has not impeded defendant Williams' right to cross-examination. Williams' motion should be denied. Caps. Argument and citation of authority. At the outset, Williams never provides authority that inquiring into vagaries classifies as a specific mode of cross-examination imparted by constitutional requirement. See generally Johnson v. State. Unlike many other modes of impeachment, attacks on witness bias are constitutionally guaranteed. Even grounds that are constitutionally protected, however, may be subject to judicial control. See Lucas v. State. The right to inquire into partiality or bias, however, is not without limits. Footnote 1, on July 10, 2024, Defendant Williams filed an amended motion. Defendant Williams' motion addresses multiple separate evidentiary rulings. This motion addresses paragraph 10 regarding state objection to vague questions. The Fifth Circuit has made it clear that ambiguous questions are not constitutionally protected and subject to inclusion by trial pursuant to the rules of evidence. Federal Rule of Evidence 611 provides the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. Make those procedures effective for determining the truth, 2. Avoid wasting time, and 3, protect witnesses from harassment or undue embarrassment. Federal R Evidence 611A, the rule permits courts to preclude questions that obscure truth because they are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. United States v. Fields, emphasis added. Williams' motion attempts to constitutionalize the areas of cross-examination that is not so protected, even assuming arguendo the vague and ambiguous questions were of the same stripe in any area like bias. Rules 401, 403, and 611A would preclude Williams' proposed inquiries. A. Williams' Sixth Amendment right to effective cross-examination is not infringed by disallowing vague questions. This court has correctly sustained state objections to Defendant Williams' vague questions because such questions are an impediment and assertment of the truth. OCGA 24-1103C holds that jury proceedings shall be conducted to the extent practical so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Emphasis added. Courts are moreover mandated per OCGA 246611 to exercise reasonable control over the mode and order of interrogating witnesses and the presenting of evidence in order to make the interrogation and presentation effective for the assertion of truth. Defendant Williams argues that the court's sustainment of objections for vague questions have curtailed Defendant Williams' Sixth Amendment constitutional right, but cites no legal authority for that proposition. Case law explains that the Sixth Amendment provides two types of protections for a criminal defendant: the right to physically to face those who testify against him, and the right to conduct cross-examination, State v. Burns. Citation and quotation submitted. However, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and whatever extent the defense might wish. Emphasis in original. Citation omitted. Furthermore, trial judges retain wide latitude to impose reasonable limits on cross-examination based on concerns about, among other things, confusion of the issues or interrogation that is repetitive or only marginally relevant. And then it has pick similar versus state in citations omitted. All defendants have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses the state calls in this trial. The state will not object to cross-examination that is legally sanctioned. Williams' right to cross-examination is not abridged where the examination is limited by the trial court to relevant matters by proper questioning. B, vague questions are improper. Defendant Williams' assertion that the court has incorrectly sustained objections to vague questions is incorrect. The 11th Circuit had held that a question or phrase is ambiguous as a matter of law, which it is not a phrase with a meaning about which men of ordinary intelligence could agree, nor one which could be used with mutually understanding by a questioner and answer unless it were defined at the time it was sought and offered as testimony. United States v. Swindle. Ambiguous, vague questions are an impediment to the assertion of the truth, because such questions left undefined by the questioner prohibit mutual understanding to the meaning behind any answer by the witness. Repeatedly proposed vague questions by Williams force cluttered confusion on the jury, whereas ambiguous proper questions provide the jury with concise clarity of the facts and better equips them to ascertain the truth. Federal courts have repeatedly upheld objections to vague questions of the type commonly asked by Defendant Williams. And then it has D. Graffiner, United States case. United States of Court of Claims held that plaintiff properly objected to questions which were vague, ambiguous, or erroneous. Again, it is paramount for courts to sustain objections to vague questions because trial courts bear the responsibility of making the interrogation effective for the assertion of truth. Gray v. Hoffman. Citation and quotation admitted. In Gray, the 10th Circuit agreed with the trial court that the vague questions asked by counsel was not helpful to the jury and approved of the trial court super sante interruption of the question ID. The prior objection the state has lodged as, oh, sorry guys, it backed out. The prior objections the state has lodged as independent phrase, vague questions asked as witnesses by Defendant Williams has not been correctly sustained by the court to facilitate assertion of truth. For example, Defendant Williams asked Atlanta Police Department Detective Belknap, do you know there are videos of countless performers and athletes where they are promoting their trade? statement objected to this question because it was vague. The question was ambiguous because it was unclear what videos, which performers, and what trade the question referenced. Court properly sustained this objection on these grounds under its inherent authority under OCGA 246611. Conclusion. Williams' assertion that the Sixth Amendment right has been curtailed by the court's sustaining of state objections to vague question is invalid and unsustainable. There is no constitutional or statutory right to ask irrelevant, vague, and ambiguous questions during cross-examination. The court's prior evidentiary rulings on this matter have been in accord with the Georgia and federal constitutions and rules of evidence. Williams' motion there should therefore be denied. Respectfully submitted this 26th day of July 2024, Adrienne L. Love. And then in her footnotes above, it was just ID, the CO9 and paragraph 10. So this is only in reference to his Steele's motion to paragraph 10, or Williams' motion to paragraph 10. And that is all four.
Okay, thank you so much. I appreciate it. Ah, Lord, I know your mouth is dry. Do you want to get some water? Because we got another one that just came in. And I sent it to your email already. Check your email. All right, guys. You got it?
Yeah.
Get some water.
Okay. I'm going to grab a bottle of water really quick.
Okay. Hey, everybody, come on. Do me a favor. Hit the like button. Hit the little emojis on the side. Let me know you're awake. Let me know you're still here. Let me see those emojis on the side. Woo, because we got a long way to go, y'all. We got a long way to go. We got a long, long, long way to go. Because they're putting motions from the past in here.
Okay, ready.
We're just reading all of them first because we have so many to read, and then we'll try to do a recap. But we're just trying to, because it's going to be so much to read lately, so we're just trying to get them read because a lot of folks are not reading them yet right now. So we're just trying to get them read. And I know you guys want a breakdown in half of this stuff. I'm going to tell you the truth. I'm not a lawyer, so I can't sit here and try to explain some stuff to you guys because I have not a clue. I'm honest. Maybe she might have some clue. I don't. And I'm not going to try to confuse y'all any worse than what I am. I can give you my own layman thought on it.
Well, the four that we just had are just repetitive.
Yeah, and it's stuff that she has done, and she's blaming them of doing something. No,
right. And once you pull them back up and you parse through them, you'll be able to see up in the motion, it says there was no response. And then in the footnote, it talks about the motion of the response. So very, very confusing. Basically states, we'll let you know which ones you can cross-examine and which ones you can't.
Yeah, and then they saying the stuff that Steele was asking was vague and repetitive and no facts and evidence. Because like when he asked about Jeffrey's sister being in a relationship with some individual, and that was not part of evidence. They just talk about all that kind of stuff.
Once we pull those up, there's a lot of things to kind of reference back to, though, because there's so much footage from the trial that defense says objection vague.
Yeah.
But you remember there was several court dates where she was saying objection vague before the question would even come out. And then one time she had to retract it because Adams was like, can I finish the question?
Yeah. It's just, all I'm saying is she's regurgitating stuff that she actually has been guilty of doing. So
that's why it's imperative for this judge to go back to day one. As bad as she does not want to watch the proceedings, I mean, hours and hours of each proceeding, there's nothing on there but a break, because the comfort breaks went for hours in between. So actual court time, there's not much to review on every single day. I have it up. I'm ready whenever you are.
All right, guys, let me go ahead and put it up so you guys can see. Hold on. There we go. We're just trying to get the information out to you guys. Here we go. All right, I'm ready.
All right. Okay, let me go up to the top so they know that this is not Love's. State of Georgia versus Diamante Kendrick. Kendrick's opposition to state's motion to restrict extrajudicial statements. Come now, defendant Diamante Kendrick, in the above style case, in opposition to the state's motion to restrict extrajudicial statements, showing the court the following. Everyone is in favor of free speech. Hardly a day passes without it being extolled, but some people's idea of it is that they are free to say what they like, but if anyone says anything back, that is an outrage. Sir Winston Churchill. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that from a form of intimidation and to further the gain and to not be held responsible. The Honorable Fonnie Williams, Fulton County District Attorney Press Conference, August 29, 2022. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present trial to be conducted in secret with proceedings happening in hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite the court's order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. After attacking the integrity of respective counsels for defendants and witnesses, repeatedly calling the Honorable Brian Still a liar, and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, the state now turns its attention to counsel for Diamante Kendrick. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them and they think it's hell. In one, sorry guys, I had to regroup myself after that one.
Sorry, guys, we're sorry.
I tried to not pause, but that choked me a little bit. I'm sorry. It says, in a 1.5-page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry picks certain comments to the rule to support its motion to instruct the defense to refrain from making extraditional statements about the case moving forward. No case law is cited. No finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood or materially prejudicing in. I'm all tongue-tied right now. An adjudicate proceeding in this matter. The state provides no specific quote of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of Rule 3.6. Instead, the state implies offer up a single conclusory statement. There is no argument that any statement made by Kendrick's counsel was known to or should have been known to have a substantial likelihood of materially prejudicing this jury. No argument was made because no argument can be made. The present jury had been impaneled and hearing testimony for months before any statement was made. The jury has been instructed at the conclusion of every day of trial by Chief Judge Glanville through his what did he call them? Admonitions?
Mm-hmm. Yeah.
I'm trying to get back in it. Sorry, I backed out. Where were we at? Where were we at? Okay. It says, this jury has been instructed at the conclusion of every day of trial by Chief Judge Glanville through his ad nosum admonitions to not discuss the case with others or with each other. They have been instructed daily to not consume any media about the present case. No statement made by counsel for defendants can be heard by the jury or prejudice this jury. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses, to wade through hundreds of minutes of interviews, find statement of Kendrick's counsel that might be objectionable, determine what Kendrick's counsel knew or should have known, and summon a reason why and how they could materially prejudice a jury that is barred from and admonished on a daily basis from consuming media about the present case. This honorable court should respectfully decline this invitation.
Yeah, he is so right. The jury's not supposed to be watching us, right? So then they're telling us, hey, the jury's watching.
And they got the admonitions every single day. You cannot consume any social media. You can't even speak with another juror on the way in. You can't do any of these things. We heard it every day.
Every day.
So now it's so important because they're having these interviews that are great. But they've never talked about what's to come. They won't. As bad as we try.
They never talk about their strategies. They never talk about anything having to deal directly with anything of the defense. They talk about their feelings about what had happened, like the what do you call it, ex parte meeting and those type of things. Nothing having to do with the case itself.
Well, a couple of interviews others have had, they've tried to get a little insight, and they have all respectfully declined. So it's going to be very hard for this judge to find anything into that matter. In addition, the state conveniently fails to quote from the presumed safe harbor comments, including the Rule 3.6 that permit Kendrick's counsel to speak in public on his behalf. Comment 5BA reads that There are certain subjects which are more likely than to not have no material prejudicial effect on a proceeding. Thus, a lawyer may usually state information contained in a public record. Each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are generally remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel finds himself in. Kennedy wrote that an attorney's duty do not benign inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney making reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Gentile versus State, Bar of Nevada, 501 U.S. 1030, 1043, and 1991. Justice Kennedy also correctly notes that the police, the prosecution, other government officials, and the community at large hold innumerable avenues for the dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense. At most, criminal defendants have insufficient means to retain a public relations team apart from defense counsel for the sole purpose of countering prosecution statements. Justice Kennedy cites that important role that defense counsel plays in educating the public on pending cases writing. Because attorney participates in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. And the dangers of their speech arise from its persuasiveness, from the ability to explain judicial proceedings, or from the likelihood the speech will be believed. These are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. ID at 1056 to 1057, internal citations omitted, emphasis added. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him. And now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful by impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays that the court deny the state's motion. Respectfully submitted, Douglas S. Weinstein.
Woo! That was, y'all, that was the bomb.
That was a mouthful.
That was a bomb.
I
That was,
said the other day in our live that Weinstein's wordplay is immaculate. His ability to write motions is impeccable. His point to get it across and using case law is always, and he's not repetitive. He gets straight to it, gets it done, and he's absolutely right. He is his client's voice. He is his voice right now. And what he is doing is to help clean up what they have had others in the opinion of. So that's a lot. That's a mouthful.
you didn't read the footnote, man.
Oh, did I miss his footnote? Hold on.
Yes, you did, man. Yes, you did.
Where's the footnote? I didn't even see a footnote. Oh, 1. The only improper prejudice to the jury that has been through the repeated eye rolling and facial expressions of ADA Love, who is sitting feet from the jurors. I said this on how many accounts? How many accounts have I said that? They are the closest to the jurors, and the actions, the eye rolling, the hand waving, the shaking the head, the death stares that she even gives her own teammate is wild.
The only footnote that is needed on this whole paperwork.
I didn't see another one. Do you see another one? Hold on, let me go down.
One.
No, there's not another one, just that.
That's the only one needed.
And it says repeated. The only improper prejudice to the jury has been through the repeated eye rolling and facial expressions of ADA Love, who is sitting feet from the jurors. And if you think that does not have an effect on jurors, it is absolutely, absolutely effective.
All right, my good people. I'm putting the link in for some folks to come on, and we got a break now because there's no new one yet. So I want to hear your thoughts on what we have read, because maybe someone who's educated in the court system can give us some insight on some of the stuff that I don't know. All right, let's I'm resting our voice. 2 minds, 1 mic. I'm resting our voice. And some folks come on up here.
You said you're resting your voice?
I said I'm resting your voice.
Oh, I need to. I just read 5 motions.
I know.
I'm on mute. I want to hear what the people have to say.
I appreciate you. Hi, y'all. So what do you guys, anybody want to come up? AJ, I know you got something to say. I know you got something to say. I hate when she's talking and says sure when they don't understand her question. It sounds rude. Who's that? Are you talking about love? I'm confused. Love can't hold a candle to these defense attorney. K. I love how he points out he once again gives a video with no timestamp, just wasting the court time. Oh, Hilton. Okay. Thank you, guys. Thank you. You know, I'm lost in the sauce. Okay, y'all. Let's see. Anybody coming up? If no one's coming up, I'm gonna take a moment's break because I have to take care of something, and I will let my two minds and a mic. See, I'm trying to say your name right. Two minds and a mic.
AJ doesn't want to come up.
I don't
That
see it. I don't see AJ. I don't see any. Robert. Bobby Halls. Come on up, my dear. That's my opposition. He gives the other side of it, and he's very well knowledge. Come on, Robert. Come on up. Come on, Robert. Come on up. Don't be scared, Robert. And thank you again, Two Minds and One Mic. I appreciate you for giving up your time and your voice in this matter.
No worries. So we have all our morning people in here. We got Marley, we have Shell, we have AJ, we have Tall Glass, we have Cavell, Lady C, all the regulars. Good morning.
Come on, Robert. Don't be scared. Hey, AJ.
What's going on, man?
How you doing, darling?
I can't call it, man. I've been reading this along with y'all, man.
What's your thought? What's your thought?
My thought while we was reading Love's Motion was it was a bunch of regurgitation. It's kind of like how she talks in court, just going in circles, not really getting to the point of anything. She seemed to be making the defense points a little bit inside of her motions. And anybody who's been watching it can see that, man. Now, when we come to Big Doug, I gotta call him Big Doug. His motion, oh my goodness!
You know he hit it, home run.
He started off with a quote from the Miss Fonnie, so using their own DA against them and their whole trying to block the media take. Man, can't get no better than that. And then he went into pure facts, and to throw in that footnote. I can't see. She needs help with her motion writing, bro. Like for real.
Yeah, you're right.
And that's only one person. Weinstein's been the one that's been a thorn in her side. But
ever since the donkey with the ears.
Ever since then. So I can't see a rebuttal because all of her, she said a bunch of nothing, man.
Same stuff in the fourth. The fourth motion, the response she had, it sounded repetitive. Same thing over and over and over. And I just need some real meat and potatoes coming down.
And it don't be. And it seems like she was, like she's been on the blogs again. Because at first, her first motion was like a half a page. So now she added all this extra stuff, like she was counting words. Like, come on, lady. You added a bunch of, I'm gonna say pointless case laws. I don't know the case laws, but I'm pretty sure they're pointless. So, yeah, man.
Yeah.
And then she started out. She's addressing motions from back when Euro was still on the bench. Like, why you ain't write it then?
Yeah.
Like, she studied not addressing the real issue.
So you think she's gonna have all of it done by today?
I mean,
yeah. They look like they're doing it because they're doing it early.
And I have a question. When at the end of these motions and the people that sign off on them, does that mean those are the people that are in a tent that's there when she's writing them, or is she just addressing
each one
in her motion? The one, I think she just addressing who she's writing to in the end of it, because I didn't see Hilton's name.
She's the one who always addresses those motions.
Okay.
Yeah. Normally it's usually Willis' name on there. Usually her name and Willis' name, never anybody else's name.
Right.
Mm-hmm.
But yeah, man, Mr. Weinstein, his motion was clear to the point, and you can't argue with that, man. You can't. And And her motion, she never addressed the truth. She was talking about, like, basically it sounded as if she was getting upset at the defense during cross-examination when they try to interject the truth. Like when Steele was asking them, the witness, about, hey, do you know they was in a relationship? That was a direct response to the question that he was asking direct about all the phone calls. She was making it seem like it was about Thug, or Jeff, when in fact it wasn't. He was asking, do you know that they're dating? Hence all the repetitive phone calls. Just bringing in the truth as usual. Where two mans go?
I'm here.
Oh,
I'm just confused at how it's only in response to a certain part, like that entire motion said this is in response to paragraph 10. So does that mean you are agreeing with everything else that was in that other motion?
it seemed like it. Because
I
she was
mean,
making this point. She was like, well, he does have this, but to this point, like, come on now. Either she's all the way or not.
so yeah, so my question is why is Hilton left off of all of these though? Because you usually include who's sitting at the table with you.
Right.
I know she's the chief deputy, so I mean, technically she doesn't have to. So I mean, that totally would make sense, but it just would be nice to see it like the others, but it's not needed. She's the chief deputy, so she can send out whatever she likes, how she likes, without
And
anyone else's stamp.
even while you were reading it, you seemed confused a bit. Like, what is she even talking about, yo?
Because I had to try to piece together like the footnotes, because where I was confused is she says it's like in response to paragraph 10, but then when when I'm reading through it, I'm like, well, wait a minute, that's not even adding up, because it's so parsed through. It's like a little bit here, a little bit there, and then you got to go down 4 more paragraphs to try to figure it out. And I'm just, it was so much more to that motion that you focused on paragraph 10 and your entire motion went off of that.
Yeah, that's ridiculous, man.
I mean, she may not even be the one writing it. She may be the one signing off on it. I mean, anybody in her department could be writing these. It could be the young ones at the back table. It could be the younger guy in between them, the referee of those two. Because the real unsung hero is the gentleman that sits in between Love and Hilton.
So if she don't declare a mistrial Tuesday, how long you think they're gonna have to go through all these motions, man?
I mean, this shouldn't even be here right now. This should have been done 7, 8, 9, 10, 12 months ago. We shouldn't even be here right now. I can't see this case past 2 weeks. If this judge entertains this case to go on with how much is on the table, a whole different conversation needs to be had. I won't even speculate down that road, but if she entertains this to push this trial forward and gets this show back on the road with everything that has gone wrong to this point, then something else needs to occur bigger.
Man, everybody in the chat saying they just can't wait to hear Whitaker's response to these motions.
Her response is going to be a breaking point for a lot of people, because you don't know which way she's leaning towards. But you know, she basically put it out there. She wants to entertain plea deals. She wants to, I don't know. I'm confused on her too. I'm gonna give it to you guys how I just stay silent about those things. I'm gonna just give it to y'all the way I feel on that. I feel like there's certain things this judge has already said that could be very imperative. Like, I'm not interested to go back to day one. Well, you can't pick up at day 103 either.
Right, but that was what Harvey said in his motion.
And I 100% agree with that. You have way too many. It's not like there's only been 3 witnesses that hit the stand. There's been 100. There's been 100 folks up there. And I've been watching from day one. I can't even tell you who the first 80 were.
Right. You got a super chat, Sylvia.
I remember Bean, Tick, Woody.
You remember all the ones she
It's obvious AJ's not reading the private messages, y'all, because I said to him, hey guys, I'm stepping away. Hold it down. I just got
I'm not I can't even remember who's come up in the beginning. I can't even remember the whole jury selection process because so much has occurred in this trial and so much messed up things have happened in this trial that if a person from the outside is watching from day one, can't remember, I'm gonna ask the chat. Chat, how many of y'all can remember from day one every single witness that they've had on that stand? If you can remember every witness they've had on that stand, hit the
100.
hit the 100 button. If you cannot remember who they have, the state has brought up from day one, hit the heart. We're gonna see what chat remembers because they are the people.
Wins. You don't think that she was all over the place with her motion?
Hold on.
Look at those hearts. Look at those. Look at the hearts. Look at the hearts. It's all hearts.
They don't remember. They don't remember. Okay.
It's all hearts. I don't even see 100 coming through.
No 100 whatsoever. Nobody could remember.
No.
I see 100, 2.
Not every single one. I don't remember. I was sitting in the courtroom, so I don't remember.
And that's my point. So look at that and think of a mind of a juror.
Yeah. I'm going to read the question. Wynn says, is Glanville supposed to be helping the DA with motion? That first motion sounds like she had some help. She usually all over the place.
It was all over the place, Wins. It was only in reference to one paragraph.
Wynn said he can remember. Come on, Wynn. Now are you telling the truth? I need you to type every single one of those witnesses that came through.
Okay, just
no.
And unless you've kept a spreadsheet.
Wait. Sean said she remembered too.
Man, look.
I remember that lady that keep coming back.
Which one?
The custodial lady. Oh.
I mean, you just look at it as a whole. There's a lot of stuff that is broken here. It's a lot of stuff that's broken here. You got the same exact indictment in that same very courthouse that got bombed, that got 12 of 13 charges dropped, and even got a letter of recommendation that they've had no issues. Not even incarcerated. Didn't even include the stabbing. Didn't include nothing. $500,000 to a rich man is nothing. They made his bond attainable. You got to look at the whole picture. The
T-Mac.
whole picture.
T-Mac, all of them but the cops. Every pertinent witnesses she impeached.
Every single one. Yep, T-Max. Yep.
And just think of when have y'all watched a trial that the state has impeached over 90% of their witnesses? It's unheard of. It's unheard of.
Every single one of them.
She's fighting against herself.
Wait. They didn't impeach D'Angelo. He said, because I'm not supposed to be here.
He said, I ain't supposed to be here.
He said, why am I here? I got my own.
Yeah, he was already in prison.
He said, what you getting out of this?
He did.
Oh, Lord.
Then he said, what was his other favorite line? Man, I don't know what you got going on. Man, I don't know what you got going on.
What you getting out of this?
And then Gaither. Mira says, Gaither, I remember her lying self. That's what Mira M just said.
The lady that admitted she didn't even want to be a cop. I didn't want to do no street cop.
Well, it was funny that, when they were asking her background, she said that she's had personal people family and people in her neighborhood that were in gangs, but that didn't make her affiliated. But it does for the ones on trial or the ones connected to the ones on trial. So it's just all doubles. Everything is a double standard. But she somehow got qualified as an expert.
I mean, not somehow. We know how. The person on the bench how.
Key said, man, she took that $20 stop lane.
Right. They ain't gonna act funny. Who that was that acted funny? That was Dennis that acted funny in front of the club and he tried to handle the money. I'm like, why you handing me this?
Okay. Black Beauty said we should do YSL trivia. See who remembers what. Oh, that would be great. That's a good idea.
Oh, yeah, that's cool.
For everybody to be lost in the end because can't nobody remember what they did in the beginning because it was so messy.
Mm-hmm.
It was all over the place.
Remember, you said Walter Murphy sound like a white person's name. Unpopular opinion. Yeah, that one was funny.
Okay, the analyst that told BBL Brown not to open the evidence and the judge agreed.
Oh, that's right. I forgot they had brought
I forgot about that one.
I forgot they brought the gun and they had the old rubber bands.
I forgot about that. Yeah.
Member still picked up the gun all crazy.
Yeah.
He said, well, it's unloaded. He said, if I don't see a clip, it ain't going to do nothing.
They bring the weed in the evidence too? Didn't they have some 10-year-old weed?
They had a bag of weed. Yeah, they did. They did, y'all. They did. Look, we were looking for the money because remember we kept saying when the money's not there. And all of a sudden we saw the money, the $200 bills.
They had the 200. Oh,
yeah, we were like, where's the money? Where the money at? What was the Hispanic?
How come they didn't speak on? Remember the detective? What was that detective's name that was working the outside job as off duty?
Talking about Dennis?
Dennis.
No, it was
fanboy.
It was the one that was. Yep, I think it was. No, Dennis was the one that was trying to get a date. Correct.
Yeah, but he also worked at that club too.
Okay, it's the other one.
Because he was doing the traffic, the traffic outside of the club compound.
Yeah. It's the other one that had the side job at that jeweler store.
Oh, you talking about the older man?
Yes.
Yeah.
Oh, because what's name even had a part-time job at the mall.
Talking about
Remember,
Quinn, the one he ran into at the mall.
Quinn.
Yeah.
Okay, so how come it wasn't discussed with Detective Quinn? He was inquiring about his daytime job responsibilities at his secondary job that shouldn't be allowed because he was hired as an off-duty police officer. So that'd be the same if you went and worked at the gas station. You should not be inquiring on anyone if you're not on that job.
And he got in his feelings because Thug offered him a job. Said, you should come work for me.
Yeah.
But he kept Thug's sister's number.
Right. Super chat.
Oh, look. Super chat Just Johnson 2023 says, remember the porn video in the Zoom? Oh, yes.
Somebody was hacking the Zoom.
That's when they stopped letting the media come in, remember?
Yeah.
They had stopped the media for a little while until after the what's the name?
Yeah, I had to secure y'all Zoom links because
Yeah.
Yeah, I remember Dennis fanboy. He came up there wearing the same color, smiling all in Jeff's face.
Well, I thought it was funny when his exact words when they were playing Lifestyle, he said it was a banger.
Right. look, love ain't like that.
Did you see her face? She looked at him like, this ain't what you up here for.
Look, you can't be out here fanning out. He couldn't hold it in. Oh yeah, you remember the bus driver lawsuit? How he suing Jeff, knowing Jeff went to death.
Yeah, we have had some characters on this case.
Well, I thought it was funny when they told the bus driver, you're suing him and he wasn't there, a part of it. He didn't know what to say.
Yeah, Adam's like, isn't it true that you have a pending?
Did anybody catch the nail polish on that last court date that we just had?
The nail polish.
I'm just gonna say that. I'm gonna see if anybody in chat know the last court, our first hearing with Whitaker. Did anybody see the nail polish?
Yeah, green. I saw the green nail polish.
Yeah,
I saw that. Slime green.
Link in the chat, y'all. Link in the chat. Who had on slime green nail polish?
What's the name? Did Love?
ADA Love. And do you see when she went to the podium, she curled her fingers underneath? You should play that, Sylvia.
Let me find out.
She had them all curled underneath.
Maybe let's see if we can find that one. Hold on, y'all.
Yeah, that bus driver was
And then pull up the part where she's at the podium. She curled all 10 fingers up under so that color wasn't out on the top for the judge.
Yeah, that's going through all them weeks about that bus trial, talking about all them phone calls, just so the cross-examination be like, so this is not where they actually was, huh? This is just the cell phone towers.
Wynn said the mall cop gave us a glimpse of what we all know. Absolutely. That nail polish got tucked and ducked when she hit that podium. You got it up, Sylvia?
Not yet. Hold on.
Most of the calls weren't connect. That's what she's talking about in her emotions. Like she's getting upset that come cross-examination, whatever lawyer decides to get up there, ask them truthful questions. Ask whatever witness or that truthful question. She's like, that's not an evidence. Like, get out of here, lady.
Mm-hmm.
It just seems like everyone's fanned out.
Yeah, Cavell, definitely fanned.
There's been some bright green blazer coats. Even went and got the church dress.
Yeah, I remember back in the day when they was matching, when Love and Hilton used to be cute all up in court.
Oh yeah, they used to do red, red, blue, blue, and
Mhm.
then they just start coming separate, non-coordinated, and out of
But you know,
out.
most teams do that in prosecution. I've seen that done.
And then there's the 4 core colors you're supposed to stick to.
The black, the brown, and the blue and gray.
And not bright green.
Right, KK, but let her tell it. That's a gang identifier.
So the green, she said, was a gang identifier. So she's been wearing it on her clothes, her nails, all, and it's been sporadically throughout trial. So it is purposely done. This is, she's being funny. Second to no one said, who remember when Hilton has DK asked DK about robberies he didn't get court for, and the judge said, don't answer that. I'm confused on that one.
I wonder what made Hilton and Love fall out. Now we just talking. We don't know if they fall out for real, but it appears as if they've had a spat or two.
It's speculation, y'all. It's
Yeah.
speculating. Oh, let me put my disclaimer up here. Hold on before folks start saying I said this. Hold on.
Wins, you are right. That is correct.
Hold on. Let me put my disclaimer up for them. Disclaimer.
Because he know his son.
Hold on, y'all. Can I finish my disclaimer? Lord have mercy.
Put the whole thing.
This is what I'm putting down right here. This is all I think could fit. Disclaimer, as a professional blogger, my role is to deliver news and information from all sides of an issue. The content shared in this channel represents factual reporting to the best of my ability. Okay. And then the other thing, the thoughts and ideas of individuals on the panel or in the chat are not the thoughts and ideas of the host of the channel. Okay. Thank you very much. All right, now go ahead, carry on.
Joe, you are exactly right. It's called being funny when DA and prosecutor does it, but when others do it, it's gang related and a gang identifier. Absolutely.
Been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well. Thank you.
Of course. And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that. Or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we
Okay.
want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just order that each of us present to the other the exhibit list that we have to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not.
Okay, guys, have you guys had a chance to see the color of the nails?
Yeah, Sylvia, I got a question.
Mm-hmm.
And somebody mentioned in the courtroom when the music is played, who's having the hardest time not to start jamming?
As far as when each time the music is played?
Yeah, who can you tell is having the hardest time sitting still? They just want to look like they want to just start.
The juror, a couple of the jurors I've seen. A couple of them, because they start like, and then they realize, and then like they try to hold it still.
They catch themselves.
Mm-hmm. But the defense, they move. The defense do.
Yeah.
I've seen Adam move. I've seen Shard move. Let's see. Those are two that still don't move too much. No, he doesn't move.
My Take TV. This judge will not embarrass the state. She will just give a professional conduct speech, deny, and move forward. That's quite a take.
Interesting.
Interesting.
Seems like you might know. Have you been in her courtroom and seen how she operate before?
That is a good point, Sandy. Still has been the only lawyer that, hasn't been out there as much as the rest. He said something, but not as much.
Who?
Sandy she has a different point. He or she has a different point of view.
What'd she say?
Do you think it's messy for the defense to be doing all these YouTube interviews while the case is still going?
I've seen cases where defense attorneys constantly talk to the news. Constantly. I've seen cases. Haven't you guys seen cases that have?
I mean, I must admit though, I hadn't seen it as much. Maybe I just wasn't paying attention, but I did find it. I thought it was a sign for something else. When everybody started getting on YouTube, everybody started doing interviews in the middle of this, I took it as a sign, just my opinion, that this was nearing its end.
And it was a big deal that happened at the time too.
Right.
I just want to see the first.
Oh, thank you, Jason. Jason just said Boosie's lawyer was just on someone's channel the other day.
That's what I was thinking, Renee. I was like, man, this shit been sitting up for 10 years. Oh my God.
Sir, your mouth.
My bad.
Yep, O.J. Simpson started the era, because y'all remember Cochran and them was on the news all the time throughout the whole trial. The whole trial, they were on the news. Even the prosecutor was giving their 2 cents in between.
Correct, Cavell.
Cavell said nobody saying none about Karen's trial.
It's not uncommon. Everybody gives interviews.
I guess y'all didn't see R. Kelly's case.
Because we keep forgetting.
Yeah, I didn't see R. Kelly's case. You saw
We keep forgetting the other.
Michael Avenatti, you saw the prosecution team was out there. Yeah, that was all over the place too.
Yeah, there are plenty of times when attorneys have started talking.
And gave full interviews. Full interviews I've seen. Yeah. Murdoch case too. Murdoch case, they were all over the television. Interviews. You said, Lynetta says, am I going to follow Sonia Massey's up there? I haven't done anything on Sonia Massey.
Sandy has a question. I think the defense should keep it low profile. It can bite them in the butt. Georgia does have a law regarding this. I checked them. Love has a point. Sandy, cite your source or come up and speak to us.
But Sandy, Willis did that same thing. She's the one who started talking about it. She went straight on the news. Remember that?
Yeah.
She did an interview. That's why Weinstein referred that to it.
She spoke on all four that was brought at the same time.
Mm-hmm.
And you see now they have since removed it.
You think so, Jason?
Because they tainted the public from the beginning. Remember?
Yeah, that was done in the very, very beginning.
Joe Blow said, maybe we should all come to the courthouse for support. 400, 500 people come on daily basis. Would that help, Thug? I don't think these people are going to be able to come. Thank you, Blue Skies. Thank you for the super chat. Lady Red said, this trial has had so many moments that are just unheard of and captivating the public. But look, listen to this. Remember when the whole the supposedly drug deal happened they let that out, and that wasn't even caught on camera. That was caught on the surveillance camera of the what's the name, and they brought it out to the public, right?
Yep.
Hear that? And that was to taint the defense.
Yep. It's cool when they do it. It's a problem when the defense do it.
Okay. All right. Here's a case that recently was quoted by one of my colleagues, Joseph, with AJC. In this case, he's basically saying that it's going to cause Jeffrey's case to be really looked upon, because this guy, let me bring it up to you guys. Hold on. Where is it? I think I closed it out. Daggone it. I had it open, the actual case. Man. His name is Brian Keith. It was a road rage conviction of a former lawyer of Atlanta. And these are the people that, and this case was overturned. Hold on. Okay, road rage murder conviction for former Atlanta lawyer overturned. Right, this is on. It says Fulton County, Georgia. The Georgia Supreme Court has overturned murder conviction of a former Atlanta attorney, Brian Keith Schmidt. Schmidt was convicted in 2022 of killing a man who allegedly damaged his car with a golf golf ball during a road rage incident. He was given a life sentence with the possibility of parole by the jury in Fulton County, right? Overview of the incident, right? The incident occurred on July 30th, 2019. In the Sandy Spring area, Schmidt was driving through a residential area where he saw 60-year-old Hamid, I can't say that man's name, but Jay, standing by the road. Jay reported made a throwing motion with his arm, resulting in a loud noise and an impact on Smith's car. Smith turned his car around and confronted Jay, and an argument ensued across the street. During the altercation, Smith decided to turn into the driveway of Jay while standing, resulting in Jay being struck. Smith's defense. During the trial, Smith claimed that he turned into the driveway to try to sort out what happened and to see if there was any damages on his car, to his car. Smith says misjudged the turn radius of his car and never meant to hit Jay. He also said that he lost his focus on Jay when he saw the trash can directly in front of him and instinctively cut his wheel to the right and hit his brake to miss them. Smith claimed that after he struck Jay, his military trainer hit in and jumped out of the car and immediately began to render aid. Throughout his testimony, the lawyer referred to the incident as an accident, and he said he did not intend to harm, hurt, or scare, intimidate, or kill Jay. Witness testimony. One witness said that Smith told him that Jay threw a golf ball at his car and that Jay jumped in front of his car. He also said that he had offered Schmidt his contact information and the lawyer declined, and Schmidt's demeanor was very emotionless, very plain, and nonchalant. Another witness testified that although she did not see the incident, she reprimanded Schmidt for attempting to move Jay, left under his back bumper. She said that Smith told her that Jay was walking and threw something at this car. Smith also claimed that Jay pushed the trash can onto his car and the trash can bounced off his car, hit Jay, and knocked him over. The fire department captain testified that Smith told him that he did not know what happened or remember if Jay was hit. The captain said Smith mentioned something about a golf ball and that Jay was yelling at him. A paramedic who responded to the scene testified that Smith seems not to remember if Jay went up or over or underneath the car, and the paramedic was a little struck that there wasn't more emotion or concern. During the trial, the state cited Smith's conduct and demeanor before, and during, and after the collision as proof of criminal intent. Supreme Court ruling. The Supreme Court ruled that the trial court erred by not instructing the jury on the defense of the accident, as there was sufficient evidence to support this defense. The court also determined that the state failed to demonstrate that there's an error, that this error was harmless, right? And hold on a second. However, the court confirmed that the legal sufficiency of the evidence to sustain Smith's conviction, allowing the state the option to retry the case. The decision to retry now lies in Fulton County District Attorney's Office. Okay, now, Joseph basically says that this case here, because this guy, he was given bond throughout the time of this case of the murder. I mean, not murder, accident. Hold on. I'm going to read to you what he said. Joseph says, hold on. He says here, the golf ball spat led a fatal encounter. Young Thug case could be impact retrial, right? And the reason he says this is because he said, listen to this. He says, Atlanta attorney Brian Keith Smith, whose murder conviction was overturned in the 2019 death of a real estate investor, Hamid J, was granted, he was granted a $500,000 bond Thursday while he awaited his second trial. Did y'all hear that? They overturned the case. He was convicted of murder, right? The judge is giving him a second chance to do the case over, and they gave him a $500,000 bond while he awaited his second trial. He's a convicted felon. He's convicted because right now he's considered convicted, right? Even though it's overturned. The same thing with Lil Ride, right? Lil Ride was convicted and his thing was overturned. But they didn't give him a bond. They gave this guy a bond. You guys listening?
Yes.
Yeah. So what do you
It's a
guys
lot
think?
of people that get a bond.
What do y'all think about that? What's your opinion on it? Case said, Case said, Nobody's saying anything?
They overturned it off a reason. A reason.
But he's
Singular.
convicted. Now, he's considered a convicted felon. Okay. Remember, they didn't give Melly any a bond. Nardy Nard said different strokes for different folks. He has a complexion for it. All corruption. What color is he? You know what color is he? You saw what color he was. But Fulton County is a whole bunch of black people in now. Fulton County now. Come on now. The DA's black. Everybody's black, seem like, in that county.
Yeah.
Look what Elaine said. Why can't off-duty cops during a second job wear their cop uniform? If they're off duty, they shouldn't wear their APD uniform. Here you can't. If you're a police officer and you get any second job that is not with the police department, you cannot put on the uniform to go to your secondary job. You have to change into either a security uniform or your street clothing. Do y'all not have that?
Nah, I'll do
They
the
could,
Wear it.
Nah. If you a cop and you working in an official capacity, you got the uniform on.
Yeah.
some said some secondary jobs is paid to the state or county, and that is why they wear uniforms. A jewelry store wouldn't qualify.
But listen, they report their income as well on the second job here. So they are allowed to do that. They report it. They have to get approval from their boss to do these part-time jobs. All right, y'all. I'm gonna take a break from my my duties here, and because I got to take care of some stuff here. I got to go to the market and all that. So if something drops, I'll be back. But right now, I have to take myself to take care of some stuff. All right. Thank you again. What AJ just flew off without even saying goodbye.
Dang, bye, AJ.
Yeah, bye, AJ. Okay, thank you to mine and one mic. Guys, I will be back as soon as some more stuff drop. But I gotta, life goes on. Life goes on. All right. Jason, I'm supposed to go with Big Jeff tonight at 4:00. So we'll talk about that later. All right, my good people. I'll see you guys later. All right.
Have a great day, everyone.
All right, y'all. Thanks again to Mike, to Minds and Mike. See you later. Bye,
You're
guys.
welcome. Bye, guys.